Everybody. Welcome everyone to the meeting of the subcommittee to study regulatory change. I know it's been a little while since we got together, so it's good to see so many of you again. I do want to start by reminding everybody that it's the duty of committee members to avoid conflicts of interest in performing their duties as members of the committee to study regulatory change and the North Carolina State Bar. Any member of the committee who's aware of any personal conflicts with respect to matters before this committee should disclose those at this meeting. And I assume nobody has anything to disclose, but if you do, please raise your hand. And again, I welcome you to what I'm hoping may be the last meeting of this committee. As you know, we've done a lot of work over the last 2 years. I think we've learned a lot, and we've also made a lot of recommendations. I really wanted to cover a couple things in this meeting. I think the primary one is to kind of update you where we are in connection with our recommendation for paraprofessional licensure, as well as our recommendation on regulatory sandbox. And so there's been some developments. So I'll give a little bit of history, tell you about where we are, and give you my thoughts on a potential way to proceed. And then I'll invite others to chime in with their thoughts as well. So as you recall, going back to the very basics, this is a study committee. So our goal has been, and what I think we've accomplished quite well, is studying what other jurisdictions are doing around regulatory change. And we looked at a lot of different areas, and then we've actually voted on each of those areas in terms of whether or not we felt they were areas for additional potential study. And actually, as I look at the agenda too, I guess we're also supposed to approve the meeting minutes from our August 24th meeting. That's the last time we were together. I do think going 4 months in between meetings is a record for us because we were meeting just about every month. But so I almost forgot the minutes piece. But those were attached to Brian's email from Tuesday. Anybody have any comments or corrections on those minutes? All right. If not, anyone want to make a motion for approval?
So moved.
Second.
All right, that's been moved and seconded. All those in favor say aye.
Aye.
All right, thank you. Those meetings, the minutes are adopted. And again, they call a pretty good review of what we did last time. So we reviewed, we studied issues, and then we voted on various recommendations. I think in terms of action, what we have voted on and recommended was action in 2 areas. We voted back in the summer to recommend moving forward with paraprofessional limited licenses. As you may recall, we made that recommendation to the executive committee. Then at our more recent meeting in the fall, we also recommended moving forward with a regulatory sandbox. And the officers and the folks in the State Bar staff have been working on how to move forward with those recommendations, both on paraprofessional licensure and regulatory sandbox. And I think it's fair to say there have been some hurdles to moving quickly forward with a paraprofessional licensure program. I think one of the biggest hurdles is really a time and staff issue. As you know, there's only one Brian Oaten, despite my repeated requests that he be cloned and copied. And I understand that technology is becoming more available, but we only have one Brian and Alice. And I think as we were looking at what would be involved in terms of creating potentially 2 large committees and the staffing involved and the number of counselors involved, I think there was a decision that was probably impractical to move simultaneously with the regulatory sandbox proposal and a committee developing that, and with the paraprofessional limited licensure program. Just from a staffing perspective, I think it was challenging. I think the other thing we were hearing from some counselors was some skepticism about whether a paraprofessional license program would really have significant impact on access to justice. And I think they were voicing concern, and certainly one of the things we found is there aren't a lot of successful programs to point to. I think we all looked at Ontario. I think Ontario is the best example of what I think we're trying to accomplish. It is obviously not a US program. You know, the history of US programs is more limited. So there was some skepticism about that, some questions about how it would impact different practice areas and what practice areas would be covered. And there were some concerns from a funding perspective. Unlike some bars, you know, we don't do the licensure. So I think we all recognize we would have to probably have a new licensing body form, something like the Board of Law Examiners, but for paraprofessionals. And so there were issues about how that would be funded and staffed and what kind of legislation would be necessary. I don't think the conclusion should be that any of those are necessarily impossible hurdles to overcome, but I do think it looked like it would be very challenging to try to move forward with that quickly. And I think those stood in some contrast to the regulatory sandbox model, which we're also recommending, which has been adopted by several other states. And I think there was a sense that that our legislature in particular might be more receptive to a regulatory sandbox model, given that they just adopted a financial sandbox to explore financial things. So there's kind of a model and a template and more openness to that. So what I was brainstorming with some of the officers and staff as we were thinking about kind of how to prioritize the two programs was whether there is some way, you know, to accomplish both. And because I do think you can look at and perhaps implement a paraprofessional licensure program under a regulatory sandbox regime. In other words, you could, the sandbox model, as you will recall, basically invites people to submit proposals to say, we want a waiver from aspects of the regulation, i.e. some of the rules of professional conduct, the limitation on practice of law. That's the whole idea of a sandbox. So we could certainly entertain the idea that paraprofessionals without further, without getting a law license could do some of the things we talked about in terms of representation in custody cases, representation in landlord-tenant cases. I think that would be an appropriate proposal to think about in the context of a regulatory sandbox, and they could propose training programs that paired up with those. The thing that's appealing to me about that idea is I think, A, it could be quite a bit faster because the regulatory sandbox, you can invite the proposal to outline what the training requirements are or the other details. So it's not something the state bar has to adopt and develop and get passed by the council and present to the bar. It can be processed through the regulatory sandbox. And maybe even more importantly, I think it creates an opportunity to show real world impact. I was certainly persuaded. I think many of the people on this committee were persuaded that we may be able to move the needle on access to justice if we get paraprofessionals involved in providing services directly to clients. I think a sandbox is potentially an area to prove that and show the impact and perhaps allay some of the skepticism about the impact of the program that, in my view, may then lead to more support for a more formal, permanent paralegal professional licensure plan. So I think as we were talking about it and prioritizing it, I think it's my view, and I think Alice and Brian share the view that probably the best use of our resources right now is to focus on excuse me, adoption of a regulatory sandbox and have a component of that, an expectation that one thing the sandbox will consider is paraprofessional licensure, but it will come up through that process, be reviewed that way and evaluated. And I think on balance, I'm persuaded that that is a good idea and probably the most efficient way to use our resources and staff. So that's what I want to put on the table as my recommendation is that we move forward with the idea of a regulatory sandbox with a paraprofessional component, as opposed to kind of two separate parallel tracks. Brian, let me call on you first and see. I know there are a number of aspects that we talked about, so there may be components that I moved quickly by. So anything you want to add? And then I think I'll open it up to more comments from members of the committee.
No, I don't really have anything. I think you did a really great job summarizing kind of the idea here. And the idea, I think one thing that I will say I agree with this proposal. And really that it's, I feel like I want to emphasize it, that it is not a pullback on this subcommittee's prior recommendation to pursue or at least to continue exploration of a limited license, but that this is kind of a pivot to address it in a different way to garner additional support for it. I think making or proposing something similar to that which has already been pushed through the General Assembly this year, that being the FinTech sandbox, the sandbox for financial and insurance services. I think that puts it on some solid ground to show that, you know, something that is already going on in North Carolina, something that, you know, we could essentially adopt a similar model for legal services. And so I think that's I do look at it as garnering more evidence. I think that was something that we talked about at the very first meeting. All these different regulatory change ideas and initiatives that we've seen, not just in other jurisdictions, but in other countries, they have not demonstrated additional harm, but they haven't necessarily demonstrated an increase in access to justice or necessarily like a lowering of the barriers that people experience to access legal services. So I think, you know, kind of opening up the idea of a sandbox to include a paraprofessional license really would generate what I would expect to be additional evidence that this limited license could work. It could serve people efficiently and effectively. And I think that's an important thing to keep in mind. I think you summarized the concerns from a staffing perspective very well, that there really isn't, I guess, the ability to take on these two different very significant tasks at one time on the bar staff. But of course, you know, the details here are something that need to be explored. This was a study committee, and the next step would be kind of exploration of the ultimate result. And the details are very important. And I think we need to hear from a lot of different voices as we iron out those details as to what exactly this sandbox would look like, what the parameters are for the participants, as well as the services that are available. But I think this is a wise move. So I'll just kind of leave my comments to that.
Thanks, Darren. Thanks, Brian. Let me, and you make a great point. We voted overwhelmingly in favor of recommending that the State Bar move forward with paraprofessional licensure. I'm not recommending we reconsider or change that vote. I think we're all in agreement that this is worth pursuing. I view this as really more of a tactical, what's the right use of resources now? If we can't pursue both, how do we achieve those objectives? So I think this is a better way to move forward, but I'm not proposing we change our recommendation that this is something the bar should move forward with. And I think that's the view of this committee, is that it is something we should move forward with. Let me open it up for some comments and questions. There's probably more to discuss, but again, you know me, I want people to participate, so it's not just me talking. So who wants to kick things off? You can just raise your hand or unmute or whatever. We'll go around.
I have a question, Mark.
Yes, Camille.
So one of the things I would say in response to, you know, the fact that the committee met, you know, for a little more than a year, month after month after month, and did a whole lot of work. And then we took our vote at the end of that period of time. And we were, I think, very clear. I think even some of us said things like, we would like to be moving forward in multiple areas on multiple tracks to make sure that we start seeing some results. So with all due respect, Brian, when you say that this is not a pullback, I completely disagree with that. I do believe that this is a pullback from what the committee voted on and what the committee decided. Now, I understand limitations. Everybody faces limitations in every aspect of their work and life. So I'm not immune to what you have to say about that, but I want to be clear that I believe this is a pullback, and that I do believe this is a totally different path than what we were discussing. And so I'd like to hear about some other options for going forward on the path that we first decided before we go down the path of, okay, we're all bought into this, unless I'm the only one that's not bought into it. So, you know, I would want to know, you know, what exactly are our budget restrictions. What exactly are our staff restrictions? One program I'm thinking about is the PMRB program. You know, why do we need to keep moving forward with that? I mean, is that a program that's actually going to go anywhere? Could we pull some resources from that, including staff, to work on this program? And if not, why isn't access to legal service considered at least as important as another sort of, you know, test for lawyers to take? So those are a few of my thoughts. So I'm going to stop there and let others speak.
I can offer, just as far as the PMBR program that you referenced, there is, you know, Leonore and I have worked on that over the past 2 years. The first year was very intense. That was, I think, 2019, when we were kind of hard at work on that. 2020 and 2021, it has not involved as much staff time. It's been mostly in the hands of the committee members, as the similar programs in, say, Illinois and Colorado were really in the hands of the volunteers. So there is really very little staff time that's being spent on PMBR at the moment. And that is something that I think is about to come to an end. So as far as staff resources, I mean, it is true. We've got a lot of different things that the State Bar does. As far as who staffs this committee and the development of the license, that's where, you know, it would primarily look, I think Alice would be looking to me, as well as, you know, I don't know if there's any other folks on the fourth floor, but of course the Office of Counsel has a lot of staff that's focused on discipline. That continues to be our primary objective. So I think that's something. I see Alice has her hand raised, although she's not supposed to be speaking because you're sick, Alice. But I will cede my time right now to see what you think, Alice.
Okay, Brian, and I apologize for the way my voice sounds, everyone, and hopefully you can hear me. But that's a really difficult question, Camille. Frankly, we have no money budgeted for this project, specifically for this project, and however many branches it might take. We were thinking that in terms of it setting up an ad hoc committee, there's obviously expenses to running a committee. But my concern has been that the long-term projections on the costs of, you know, if you set up a program, how are we going to actually finance that program? We can come up with, you know, the policies and the structure working through a committee at, you know, a reasonable additional cost to the State Bar. But I think the actual structure, you know, is it going to be supported with application fees? And if so, how big will those fees? All of that is stuff we haven't really worked through. I think also on the resources, we have to look at our staff. And frankly, the Office of Counsel, Catherine's office, where our discipline lawyers are, is already stretched very thin. She knows that I routinely ask her to lend me a lawyer to staff special subcommittees, but that stretches them very thin as well. So what you're really looking at for staffing on this, and again, it's, you know, it depends on how many different directions we go in. You're really looking primarily at Brian, who is already stretched really thin. So, you know, part of it in this, looking at this recommendation from my perspective, is how can we best leverage the resources that we do have to accomplish as many of the goals as we want to accomplish. And it really seems to me that the Regulatory Sandbox offers us that opportunity. We will have to address the question of, you know, financially, once we know what direction it's going in, you know, how is it going to be supported? What would be application fees and et cetera. But if we have that question on two fronts, it really magnifies the problem. So, you know, without having, you know, written out a long thing on this, I hope that was responsive to your concerns to some extent, Camille.
Thanks, Alice. I think the other thing I would say is, you know, we made recommendations on a number of different things, including things like, some of the non-lawyer ownership or modification of the rules. I think the sandbox gives folks an opportunity to try a variety of different ways to improve access to justice, one of which is the paraprofessional licensure. So to me, it gives an opportunity to move more quickly and cover a variety of options as opposed to just focusing our resources on one. So if we're trying to prioritize which the state bar should focus on first, that seems like a potentially advantageous way to focus. All right, and let me get comments from other folks.
Mark, I have a question.
Yeah, Ashley.
It's Ashley. I share Camille's concerns. I feel like for the group, I just feel like this is sort of coming out of left field. I did not anticipate this. And it seemed like this is, an area which we all had, we had pretty much unanimity and voted on this, I think, quite a while back. I do have a question about the regulatory sandbox. I understand what you're proposing as a way of trying to do potentially both. If under that scenario, would different paralegal groups need to make proposals to the regulatory sandbox regulators? And then they would consider those proposals individually?
That's what I'd envision, right? Is you get a group of paralegals that say, and obviously we've got folks in this committee that worked on a pretty detailed proposal with the Access to Justice group. So they could take that proposal and say, this is what we'd like to do, and this is the population we'd like to serve, and this is the training we propose. That's right. And then the sandbox would evaluate that proposal in terms of scope, potential benefit to the public, any risk to the public, and then then they would make a recommendation. Ultimately, the state bar approves those programs, so that would come back to the state bar for approval. So I think that's the broad structure. There's a lot of questions about how is that done and implemented, and what I think would have to happen to get to that point is we need a committee that will actually develop the sandbox proposal that could lead to legislation and oversight and figure out who's going to run it and how are they going to evaluate the programs and how's the state bar going to approve it. So there's definitely a lot of work to be done to get from the general concept of you submit a proposal and it either gets approved or doesn't. But that is the idea. And I do think that's different. It's an important difference, Ashley, to what we initially proposed was the state bar would come up with a proposal for paraprofessional licensure and make proposals around how, who's going to issue those licenses and what the training is and how much they'll have to pay for licensure. That is different in a sandbox mode. A different organization would actually propose that structure, and then the sandbox committee and the state bar would be reviewing that proposal rather than developing something from scratch. And I think that's part of the real challenge is, and I think some of the skepticism is, to develop a brand new program for limited license paraprofessionals is a significant undertaking. We remember we had timelines looking out, 2-3 years. It's a long process with a lot of investment. And I think some of the skepticism was, is that going to work? And are we going to have a program that has sufficient impact? And I think that's part of the challenge in trying to move quickly just with that program is I think it became less workable to try to make that happen. And so the sandbox offers a potentially better process.
So it sounds like that there was some skepticism about whether the program could work and whether it would serve its purpose. I wonder, was there also some skepticism about whether limited licensing paraprofessionals are going to negatively impact the ability of lawyers to get business?
I think it's fair to say that was a concern in some areas in particular. I mean, it depends what areas where you're looking at, when we had recommended some areas, again, wasn't our job to try to outline exactly what the program would be like, but family law is certainly an area where there's both high need, but also some concern about what are the right limits, what areas should paraprofessionals do, what shouldn't they do, what kind of cases. So I definitely think there's some skepticism around that. I know that's part of the challenge too in trying to create a committee is who's going to be on that committee, who's going to set those parameters. So that I think that's part of the challenge is what are the right areas for where the practice is going to be impactful? And is it going to be areas where they're competing with existing lawyers, or are they going to be, doing new service where folks currently are not getting served, and how to measure that impact? I definitely think that's fair to say that's a challenge.
I'll offer just, in response to that, Camille, that is not what drives my feeling on the subject. I think ultimately, as I was looking at these different ideas, and I kind of looked at it, the sequence of recommendations, you're right that the recommendation or the vote on paraprofessional licenses occurred first. But we had like a sequence of meetings and where we were looking at a lot of different ideas: document preparer programs, court navigators, fee sharing with non-lawyers, just the overall liberalization of the unauthorized practice of law, in addition to the regulatory sandbox. And so I guess in my position, I was looking at the end of that, after that August meeting, we have a lot that this committee or subcommittee recommended we continue to pursue at the state bar. And so how do we do all of that? How do we pick and choose one over the other? Or is there a way to do everything and kind of test it all out in one spot? To me, that's where the regulatory sandbox seemed to offer an opportunity to test this all out. I will say I've heard some skepticism myself. I've heard some questions. I don't think there's any question that there's a need for something to be done. But what that is, even looking at the paraprofessional licensure, I mean, the best example we had, like Mark said, is Ontario. You're talking about after 10 years, they've added about 10% of their overall lawyer population is kind of reflective of their paraprofessional or licensed paraprofessional population. And is that something that's going to significantly alleviate the need for legal services? I don't know. I think, but that's where we have kind of some different ideas, that some of which we think are really feasible. We think that they could make a positive impact, but they are ideas. And I think that's where it started occurring in my mind, that in light of all the stuff that we are recommending here, and my personal desire to do what we can to explore these things, the sandbox seemed like it was the best opportunity to accomplish as much as we could realistically accomplish, but also start building up evidence for all the things that are right now just ideas. And that would provide hopefully some strength to the ultimate conclusions, which is at the end of the sandbox. You look at everything that's been done and you start saying, okay, so we saw that this came into the sandbox, was really effective. We may need to adjust our statutory language to permit this type of legal services to be provided in North Carolina. Whereas we looked at this type of thing, we had a couple of different participants in this particular type of delivery method, and it just did not work. It resulted in harm or wasn't very efficient, whatever the case may be. But it ultimately presents evidence upon which the future of the profession really can be reviewed and reevaluated, as opposed to us kind of trying to fight over ideas. Not really fight, fight's probably the wrong word, but debate over different.
I think it's probably the right word.
That's where my thought process is, kind of how it's evolved, for whatever that's worth.
This is Joshua.
Yes, go ahead, Joshua.
Yeah, so I actually, at least in my mind, wouldn't call it, what's the word we've been using? Skepticism. That's not the word I would use. I would probably use, down here in southeastern North Carolina, I would probably say real world realism, because as some of you may remember from my comments, I've been concerned all along that we're trying to bite off too much, and you can only put so much in your mouth at a time, or things are going to fall out, or you're going to accidentally swallow them. I'd rather put one or two things in my mouth, give them a good gnaw, and try to do it the right way. And I think this is, at least for me, is more, makes more, I'm going to say common sense, but I don't mean that to offend anyone. I just think it's a more realistic route to go about it this way. Because I was concerned, I mean, everything that came to the committee, let's be honest, everything came to the committee. Brian, did we say no to anything? Was anything told no to?
Very
only
little.
thing-
I think
yeah,
one thing
there's-
failed, but yeah,
What-
Yeah.
we
one
did. We
thing,
liked
that was
almost everything.
alternative admission to the bar. Alternative admission to the bar received a split vote, so it did not receive a recommendation.
And obviously, I hear you very clearly, and I don't necessarily disagree with everything you're saying. I just think this is a more realistic approach. But I'm just a country lawyer from southeastern North Carolina. Maybe we don't try to take on too much at a time. We try to take on a few things and do the best.
Mac?
I don't have any down home Eastern ways to say it, but I think I agree with Joshua. If this is the piece of this that we can get, and it appears that now there's a legislative precedent for it, feels to me like that's the practical thing to go for.
Thanks, Mac.
This is Lakeisha. I have a comment.
Yes.
I think that it's pretty interesting that when we talk about these programs, we talk about how there's not enough data to show that there's going to be this, what impact it's going to have. But when we talk about lawyers, businesses, and we talk about the kind of resources and things that may be needed for the program and what hurdles we may have, that we have this clear vision of what that's going to be. I don't see how we can say, well, let me not go down that road. Let me just then back up. So then I have a question then for Mark. The way that you describe the sandbox is what you're saying is that we will have to submit a proposal and that proposal will have to be approved, which means proposals may not be approved.
That's right, Lakeisha. I think it would be up to paralegals or different groups of paralegals to submit proposals to say, this is what we would like to do. This is what the idea of a sandbox is. It's essentially a trial program where you can ask for exemptions from the current rules. So, for example, if you want a paralegal to appear in court, that's going to be an exemption from the current rules around practice of law. So you would submit a proposal saying, this is what we want to do. This is the type of paralegal or training or background and the cases they would handle. And then that would be subject to approval through the sandbox process. I do think I think that is a quicker and easier process than the multi-year process of trying to get a formal, permanent, limited license paraprofessional program adopted by the bar. So that's the appeal to me, is I think that's a way to get some programs in place quicker, to demonstrate success, with the goal, in my mind at least, to prove that those are having a positive impact and are a reason to then adopt a permanent licensure program. So I think that, but you're right, it would require, there's no like pre-approval to say this will automatically get accepted. It would have to be evaluated like any other proposal submitted to the regulatory sandbox to determine.
As a follow-up question, then what would prevent you saying at that time there's no proof that there's going to be any positive impact by this proposal? I mean, what would be the difference?
That's a great question. I mean, I think my understanding, and Jeff Kelly may chime in because he's our sandbox expert, but my understanding is with the idea of the sandbox is you're generally trying something that hasn't been done before. So there's less expectation that you're going to be point to a track record of success or impact. The idea of the sandbox is you believe you can make a positive difference. You want to try a new proposal and you propose some metric to measure it, to demonstrate the positive impact. So I think there's less feeling of, I can point to 10 other states that have already done this. That I think when I mentioned some of the skepticism, I think the concern that I heard from some of our other counselors, you heard a little bit of it from Joshua, is, it's a lot to go out and, be the first state to do it, other than Washington State, which did it and then only had 50 people and canceled the program. So I think there is some a sense of this seems like a big investment and risk if we don't know how it's going to happen. I think the test in looking at a sandbox proposal is a little different. Jeff, you've got your hand up. Go chime in.
Yeah, and for the record, I'm in favor of both. But to answer the question that I raised my hand for, yes, it's not something that we're going to say, okay, show your data and prove in your proposal, but how the sandboxes there's now 4 in operation operate pretty much to a T is once you have certain criteria, you're assessed on risk factors. So it's no longer about I can come to you with data that I've never been allowed to collect. Instead, you're coming with a proposal that says, these are the different ways that I would like to deviate from the existing rules of professional conduct or other statutory limitations. And this is how I'm going to account for the risk. And in collaboration with the administrator of the sandbox, we're going to operate and monitor and report on it. So in that sense, it's a runway to build the data that I would hope would lead to more permanent programs. One of my concerns, but only a part concern on sort of not having both a paraprofessional model and the sandbox operating, is that these are typically programs that require a decent amount of investment. So we're talking about educational programs that will train the paraprofessionals. And so I know I've asked some questions in the past about if we're going to have provisional licensing processes, how do we make sure that the people that are organizing these things are going to get and even an opportunity to have the benefit of their program and investment, which is to say, if I go through, build a curriculum for since a landlord tenant paraprofessional that handles a certain area, and only to have that sort of canceled before it launches, that's something that I would want to have some type of additional considerations. It's not something I think is improper or impossible with the sandbox. It's just something that would be different from if we were to introduce this without a paraprofessional model. And I linked an example of some of the additional training programs that I think at least speak to this, of how a sandbox might handle having folks that are not lawyers providing legal services and sort of creating a threshold of training. So the AAA Fair Credit Reporting is the only, and I double checked to make sure I'm being accurate here, the only high risk entity that's been authorized in Utah. And what the training program is a program that was created by University of Arizona's Innovation for Justice program. It's being administrated by one of the Utah universities there, and it's about a 70 to 80 hour accreditation process to help people become qualified for what's called a medical debt legal advocate, and provide sort of without lawyer supervision assistance in kind of medical debt questions. So I could see that being something that is sort of a standalone project. I think realistically, a lot of proposals are going to be extensions of existing legal practices or adding on professionals with some level of supervision. So it's really a question of, where do we see the limitations on having me as a standalone citizen who is not a lawyer but wants to help? How can I opt into a program without joining a law firm? Because then we run into the same problems and limitations.
See, Alicia, you have your hand up. Oh, sorry, Mark, were you trying to say something? You're on mute.
Muted. I'm sorry. I think I saw Alicia's hand first and then Ashley's. So Alicia, go ahead.
I do have a question. In your mind, anyone who wants to answer, would the requirements to get into the sandbox be less prescriptive than it would be for a standalone program? I'm having a hard time working this out, because if a group of paralegals got together and they submitted a proposal, and the sandbox overseer determined that there was, too much risk for this proposal, and they're like, well, you need to go get education, or you need to go, complete these other steps. I feel like that they would be at a severe disadvantage and compared to the business structures that would be inside the sandbox with the attorneys. And then, if these paralegals say, group of 20 or 30 or whatever paralegals, submit this proposal, no one's going to create, Jeff kind of already alluded to this. Nobody's going to create an education program for just, a small group of paralegals. I just, I'm trying to just wrap my mind around some of this. And I understand, this is very preliminary. It seems like, the devil's in the details. I talked to, I mean, I've talked to a couple people. I've talked to Justice Simonis in Utah because I was trying to wrap my mind around the sandbox concept. And I mean, I think what I took away from that conversation, not saying that he said anything in particular, but I think what I took away from that conversation is, you know, when they were setting up, you know, their paralegal program and the regulatory sandbox in Utah, you know, he said that there wasn't as much, you know, there wasn't so much pushback. Like the state bar president at that time was very supportive of it. And so they kind of did it kind of hand in hand. I have some concerns that if our state bar leadership is skeptical and, you know, and then we've got, you know, bar members who are skeptical that this, you know, paraprofessional, whatever it's supposed to be in the sandbox is going to end up in the quicksand.
Let me take a stab at answering that because I think that's a good question. Then I'll see if other people want to comment before we go to Ashley. I mean, it's certainly my hope that this is not an effort to delay it. I'm trying to come up with a most realistic way to move forward. I think it's a good program. I think this committee feels like limited licensure is a good idea, you know, for the state bar to pursue, and we've certainly voted that way. I think to me it is how do you get there, and I do think the sandbox may be the best practical option. To your point, I think you're right. I don't think the sandbox program is going to be identical to what a permanent licensure would look like. It would be more limited training because it's going to be, you know, probably more focused. So it's not going to be some lengthy training program, but I could see something saying, we want to handle this kind of cases and we're going to go, you know, we're going to do a 8-hour class on landlord tenant and start representing tenants in eviction proceedings, or we're going to do a 20-hour class and start handling custody matters where neither party's represented, or come up with a more targeted area where we've identified needs. We've spent all that time looking at the huge number of people that get no lawyers and have pressing legal needs. So I think looking and targeting some of those needs and saying, how can we do that? My hope is that, you know, that the sandbox assessment's going to say, we're willing to try a lot of things to address those needs and, you know, try to move something forward that could make an impact, as long as we don't think it's a real danger. So I view it as a way to try to move things forward more quickly, not delay it. Barbara, I see your hand, but I think Ashley Campbell had her hand up first. So Ashley, let's go to you and then Barbara.
Thank you, Mark. And I want to, before I make this comment, I want to say to you and Brian, I do not question your commitment to this work and to expanding access. I know you're committed to it and just trying to come up with a way to move forward. I just want to make a comment just for the leadership of the bar that's on the call and just publicly, which is that I want to continue to encourage us as a bar and as legal professionals to be bold. You know, when we talk about what other states are doing, or we may be the first or second state to do something, that takes courage. And I think we need to have courage to be innovative and to do things that other states may not be doing and to take risks. This is a significant problem. We all know how big this problem is and how the people of our state are not being served appropriately. And so we've got to do something big and bold to address this problem. And I think many of us felt like, you know, paralegal licensure was part of that solution. And so when we talk about putting it into the sandbox, the concern that I have is then it's coming from individual groups who don't have, you know, the credibility of the state bar bringing that program forward and saying, this is what we want to propose to the state bar, right? It doesn't have that, the backing sort of the bar. And so I just have concern about whether or not it's going to be taken as seriously, how long it's going to take for something like that to be developed. So I just want to continue to, this doesn't require a response, Mark. This is just to continue to encourage all of us to think about what do we need to do to make this happen. If we need additional resources to staff this, I would encourage us to start thinking about how to find those resources because we know how important this is.
Thank you, Ashley. Barbara?
Ashley, welcome to the council. You've sort of been a part of it for a long time, but glad you're officially going to be a counselor. So, and I guess what I was going to say is that I'm in favor of what we're talking about doing. And I think that for those that are in favor of the paraprofessional, that this is going to be a good move, because when you're sitting at the outset trying to design the program, the people that have fears, it seems sort of magnified. And in fact, I believe that a lot of those are not realistic. And if we can have the sandbox and go through it and show some of this, maybe we come out at the end and then we're talking about institutionalizing a program, then we can say, look, we did it. And these things that people were worried about didn't happen, weren't a concern. And I just feel like if you start at the outset, you might end up with a much more restrictive program than if you're able to kind of, experiment and show that it works. So I view it as a real positive step toward implementation.
Thanks, Barbara.
Well, one of the things that I would look at if I were, in my job, when I can't get my work done because of budget or resources, I look to contract help. And so has the State Bar thought about contracting some help to get these programs off on a parallel path? So could we hire Lucy Rico on a part-time contract basis to help us develop our programs? Could we hire Jordan Furlong to come in and help us on a part-time basis? Could we, we had talked about using the Justice for All proposal along with the North Carolina certification program as sort of a basis for the limited licensing proposal. So those are just things I do when I find myself strapped for resources and money.
Thanks, Camille. Mac, I think your hand's back up, or is it? Yes, back up. Yeah, go ahead, Mac.
I think we're missing the value of the FinTech sandbox already having gone through. There are pros and cons to either of these options, of either going the way we started or going this new hybrid way. But I just think that the value of having the legislature already gone down this path is a huge benefit. And between that and letting us put it together as an experimental program, rather than having to gin it up as a full-blown program with all kinds of rules and regs on it, feels to me like a much better prospect of actually getting a program off the ground.
I just want to say, Mac, I'm also very excited about the FinTech proposal. I think that's great. And I think it lays an excellent path forward for our legal sandbox proposal, which we all voted on and obviously are all excited about moving forward. I have no problems with sandbox. Woohoo, sandbox. I'm looking forward to it. Can't wait to be a part of it. However, that's not my point. I'm not missing the value of the sandbox. I am suggesting that there is value to having a limited license professional program as well. And I am still looking at resource options if resources are a piece of this. The skepticism piece, I really appreciate what Josh said. I am from Eastern North Carolina and I get his analogy very well. But I've been trying to get us to talk about this outside of our committee for a year and have been told for a year that it was premature for us to talk about this outside of the committee in articles in the State Bar Journal or in other writings or offerings that the State Bar could do. Yet now we're sort of hearing, this is too much, too fast. And there's skepticism. Well, we can't redo the past year, but if we had brought lawyers with us along the way during the conversation, I wonder what we could have done to help with some of that skepticism. And, we had some of those YouTube meetings where we've had hundreds of people, or at least 100 plus, watching some of those presentations. So I don't know if we know how much skepticism exists outside of the leadership and outside of the family law bar, because we haven't tested any of that. We haven't had any conversations. Certainly not as a committee that I'm aware of.
Thanks, Camille. Todd, I see your hand up.
Yeah, I just want to say a couple things. I am all in favor of going in heavy if it enhances access to justice. I am fully in favor of that. And I would like for us to pursue programs that will enhance access to justice. And I think the paraprofessional program has that capability. I think it's no secret, because I was on these calls and I was on the call before I became an officer and after I became an officer, but I was one of the ones in the camp of saying that we should go slow. And that I like, on my own approach, when I approach things, I like to be able to point, if I'm trying to persuade folks to give me additional resources, to go down a new path, to go bold, I would like to be able, this is just me personally, be able to point to some programs that we might point to as models of success. And that instead of coming out and coming up with all this evidence on our own, we might be able to point to those programs as successful models that we can use as evidence for going forward with our program. And so I'm in favor of sort of a pilot type program to demonstrate to folks that this is indeed something that can enhance access to justice. Here is something that we ought to go out and get more resources for, and we ought to go to the mat for it. But in terms of persuading folks that we ought to go forward, and that is other counselors, that is officers, that's leadership, that's probably other members of our profession in North Carolina. It would be nice to be able to point to something to say, this is an example of a very successful paraprofessional program that we'd like to model after. And I'm not persuaded yet, as I wasn't back months ago, that we have one that we can point to. And so I would like to be able to say, through a pilot program or whatever, that we have demonstrated that this is something that enhances access to justice and that the state bar ought to get behind it with full force. I'm also persuaded that, we probably would benefit from having a lot of other stakeholders involved. A lot of these questions that I'm hearing on here suggest that, maybe if we can get some other stakeholders involved, maybe some of the law schools, maybe some other types of organizations that can enhance our ability to make the case for a program outside of the sandbox, but to be sure perhaps within the sandbox. And so I just, having heard all of this for months now, and knowing how other states have approached it, and some have done so successfully and some have not, and whether we're going to be able to persuade, first the leadership of the bar and others in the profession to go forward and support us. If, as we have recommended, it would be nice to have something to point to. And I think the way to get there is to go down the sandbox road. Pilot program, I like to call it a pilot program. I think they're kind of one and the same, but to be able to say, here is what you need as a foundation to put a paraprofessional program in place in North Carolina on a permanent basis, and this is a model to do it. And I think if we have that, it makes our case a lot stronger to get the resources that we need and to have the state bar support this with full force, quite frankly. Those are just my thoughts.
Thanks, Todd. Alicia, I see your hand up. I don't know if that's from before or new, but anything you want to add?
I guess I just have a question. I know, again, this is all preliminary, but I'm a little fuzzy on where this regulatory sandbox would be housed. It's really difficult for me to understand how this is going to work if I don't have that piece.
It's a good question, and I don't think we have an answer. We had talked with Jeff about the possibility of working with the center to perhaps help do some of that administrative lifting. And I know Jeff has talked about possible availability of grant funds. So I think the the thought would be the administration may not be in the bar. It may be through universities or other folks using grant money to evaluate the programs and make recommendations to the bar. And then the bar would ultimately approve or disapprove of those recommendations. But it's a great question, and I think what needs to happen, and again, I think what we're recommending is that a committee be formed to actually flesh out what the sandbox is, how they're going to evaluate programs, what we may need in terms of legislation to get authorization to do it, because we're going to need to have legislation. Again, we have a template, but we're going to have to get approval for the sandbox to give permission for people to practice law without a license, for example. That's something we're going to have to get some statutory guidance on. So we're going to need, a committee is going to need to work to actually do a lot of those logistics that would give you a concrete example. We can look at how the sandbox program works in other jurisdictions as a potential model, but we haven't done that. And again, this committee is just supposed to recommend the idea, and a new committee would take that idea to actually hammer out the implementation. So I agree with you. It's fuzzy. I think it is fuzzy because the committee hasn't adopted a proposal, and there's nothing the state bar has voted on in terms of the sandbox structure either. So that's a fair to say unanswered question on the exact process for it. Mac.
Mark, you just touched on one of the issues, and that's the legislative side of this. I think let me say, I support the paraprofessional licensing proposal as an access to justice measure. I think it's a great idea. I think getting that through a sandbox structure would be easier than getting it first through our bar and through all of the constituent groups of our bar that might fight it, and especially getting it through the present legislature. This feels to me like an easier route to try this out and to actually get it to succeed.
I agree with you, Mac. That's well said. And I think that I share a lot of that sentiment, which is why I think this may ultimately be the better way. Heidi.
Well, I was going to say the same thing. I think there is a lot of value in inertia, right? And there is inertia in that we just had the fintech legislation pass. We have a legislative sort of outline that we can look at. I look at it as maybe we have to reframe our thinking, right? That maybe this is the best of both worlds, in that it gives us an opportunity to pursue maybe not the path we all originally had in our mind in September, but sort of a splitting of that path, that these aren't mutually exclusive. They can work in concert with one another. Plus, the sandbox path allows opportunities for other programs besides just paraprofessionals. So, I hear everyone's, dissatisfaction with maybe taking a different direction than we thought we were on, but maybe we should reframe the way we're looking at this and look at it as an option, as an opportunity to have a different way of getting to the same result and maybe to more results. With somebody that already did the groundwork for us as far as the fintech sandbox goes. And, I wondered, Brian, you said at the very beginning, the details that need to get worked out. I haven't thought that far ahead. I wondered if you had. Mark said some of them, but I'd be interested in hearing from you all, because there have obviously been conversations outside of the conversations we've had about the sandbox path. Like, what are the details we would need to wrap our heads around?
I think where do we begin? I think, there's, with regards to the paraprofessional practice of law through the sandbox, I think we would have to look at, is it limited to certain areas of law? Are we going to test out certain areas of law? What type of qualifications do we have? And I think that, to me, is where we end up putting what I'll perhaps poorly term boots on the ground quicker. Because I think folks could apply, whether it's individually or as a group, or perhaps, whether you might have a firm, you might have Legal Aid, you might have Campbell Law that's doing an expunction clinic, and they're trying to get more people to do all that. that could be something where, you apply for participation in the sandbox. And I guess, whether or not there needs to be some sort of requirement that those folks that are participating, lawyer or non-lawyer, have some sort of have taken some sort of educational course on that, or received some sort of training. I mean, I think we see that currently with lawyers that are practicing in other fields for a long period of time, and then they go and do, wills for heroes or something. They haven't written a will ever, but they took a quick CLE or something like that, received some training from folks that can educate them, and that's something that we feel confident about doing. And as far as just the details of how it gets carried out, to Mark's point earlier, is this something that we can partner with Duke Law, as has been kind of sort of touched upon before? They might be interested in participating, or another university that can really take in all the data. But I guess ultimately it's this really question of what exactly is going to be permitted in the sandbox. And I think it's all based upon the threat of harm, one, to the client, and two, the impact on access to justice. To me, those are kind of like the two key aspects that every application would need to be evaluated on. And I'd like to think that, with this sort of thing, it wouldn't be a sandbox is not going to be very helpful if everything gets rejected. So I think the folks that are looking at this, that are evaluating the programs and ultimately making the call yay or nay on participation, really would need to be pretty forward thinking, also knowing that the sandbox is built in with protection such that if there's any sort of indication of harm during the collection of data, that person's participation, their pass to get in the sandbox gets yanked, and they're not in there anymore. Now, exactly what those things are, I mean, we could get into, I feel like we would probably speak for the rest of the week if we start really talking about details, but and I don't have all the answers to that. I kind of start spitballing some ideas, just like a lot of folks I'm sure can. But I do think that there's kind of that, to me, that the fixed stars of client harm and access to justice are the things that we look at and kind of craft the parameters around that to ensure that that the objectives are met. I see Jeff and Mac both have their hands up. I don't know, Heidi, if you had any follow-up question to that.
I think I'm trying to remember who was up first, but Jeff, why don't you go first, then Mac?
Sure. So Brian, I think you hit on some of the logistical points. I mean, I'm never, certainly as an advisor, going to get ahead of the state bar in terms of what this could look like, who could help. But at the same time, I work with a lot of kind of the different groups that are supporting sandbox initiatives and providing educational information about it. So in that sense, assuming that this is something that is at a big picture level, something that the State Bar Council supports, I think that the idea and the specifics for an implementation committee could come together pretty quickly. And that's, to me, has always been the struggle of advocating for a sandbox. It's not that people are opposed to it. It's just, it's very amorphous. It's very difficult to understand until you actually bolt it down. And that's why we're fortunate that at least there's Utah and comparable Canadian sandboxes in operation. But just to kind of tie it back into this conversation of whether there's a merger or combination of ideas, I haven't completely come to terms with. I mean, Alicia, I think you made the point that how do we create something that is, it's one thing for an organization to come together and say we support this initiative and we're going to make this proposal. But how do we increase or sort of legitimize, for lack of better terms, an opt-in type of program that lets the individuals stand up a program and have a little bit of credibility beyond just this is a pilot program that can go away in 12 months. It's a balance that I know that in a kind of sandbox or a pilot program, you may not be able to strike perfectly, but at the same time, that's a concern that I really have if we can't have some type of accommodation for that baked into this.
And the only thought I would add to what Jeff is saying is, I think, at least from this committee's perspective, it's clear there's support for limited license paraprofessionals. So I think if we go forward with a sandbox, one of the ideas will be to think about how to make it receptive to limited license paraprofessional program applicants, right? I think I don't think it's not a pre-approval, but we need to think, to Jeff's point, is there a different time horizon that may apply to some programs that may need more training or buy-in? I think that's something that has to be discussed by whatever committee puts together the sandbox, if that's the direction we decide to go in. Mac?
I want to add a third criteria to Brian's two criteria. His were least likely to cause harm to the public, and the second one was that it supports access to justice. I think the third criteria I would add is least likely to draw incoming fire. And I think we could probably, with the sandbox, put together a strategic thought process around which kinds of limited license paralegal programs would be least likely to draw fire from the bar and from the legislature, and incrementally build support for this in a way that is more realistic than asking for the whole thing at once, either from the bar or especially from the legislature. This allows us to do this in a more strategic way to build some support and to avoid the worst opposition. It's been clear to me, just listening to people talk as we've studied this, that there may be more fight from, say, the family law people than from some other quarters. We can be strategic if we do it this way.
Thanks. Other comments? Anybody that hadn't had a chance to comment?
Mark, I would like to ask, has there ever been any conversation about presenting both the limited license and the sandbox? Because if you're going to do the work to present one, why not present both? And I hear everyone saying we need to look to someone else, another state, to have the model that we look to and say, hey, this is a great format, we should follow it. Why can't we be that model for others to look at? I think we do have enough of the key components in place that we can be the successful limited license program if our team gets behind us in our state, opposed to challenging us. And when we talk about a pilot program, I think a pilot program is great, especially if we're talking about proposing both of them at the same time or presenting them for consideration at the same time. Because what you're going to have is, if you put the limited license in the sandbox based on what you guys are presenting right now, it's a Band-Aid, and it's still not meeting the access to justice gap that we need to have met immediately. And it's not really what it's structured to do. And the family law attorneys that have concerns, I would love for them to give me an example of what they think we want to do that we're getting this much pushback from that area. We don't want to practice wizard law. That's not what we're doing. We just would like to be able to service those who have a need. And the need is different than what you guys are thinking on a day-to-day basis. And if they would present something for us to have a conversation about, that would be great, because we want to clear up any misunderstanding, especially in the family law area, the most sensitive area that they may have.
Thanks. No, thanks. I appreciate that. And I want to be clear that I think our committee, from a study perspective, has recommended already, and we're not changing the recommendation that the state bar should pursue both. I think really this is now a question of priorities and the best way to accomplish that. And we had said, let's have a committee put together a paraprofessional program. Then we said, let's do a committee for regulatory sandbox. And I think the reality is, for all the reasons I started with staffing and priorities and how many people we have, it's going to be very difficult to really do both. And so I think figuring out if there's a way to, is there a way to use the sandbox as a way to leverage the paraprofessional and do them in that order, to Mac's point about trying to move perhaps more quickly with more legislative support and overcoming resistance. I think that's the idea in terms of the prioritization. But I agree with you. I think most of us do, that they're both things that we should be doing. And it's really a question of tactically, how do we best advance that ball? I appreciate it. Mac.
Mark, are you looking for a decision today, or are we just rolling this out for us to start the conversation?
That's a great question. So I wanted to talk about it, and you're right. This is new. I think Ashley and Camille both commented this is new. So I don't want to rush. I don't want to rush a decision if we think we need more time. On the other hand, I think, I've been it's taken a while already to get things going. So part of me wants to make a decision here so that if we're doing the sandbox and having that element in it, having the ability to move forward and get a committee rolling on that would be good too. But we can wait. We can meet again in January. This was really from brainstorming I was doing with Alice and Brian. I wanted to bring it to the committee and get reaction. So we're not on a deadline. We don't have to act now. I welcome people's thoughts on whether should we wait, and take this up again at another meeting after people had time to digest it. I'm not trying to surprise, bring a surprise shift to Ashley's point. So that's definitely an option. So, I mean, if someone wants to suggest we act and make a motion, we can do that. But I'm also okay having this discussion and then, coming back together one more time because, we spent a long time. I'd rather get it right than have people feel rushed or pressured into a decision today. Thoughts on whether we should act now or later? Who wants to chime in on that? And Mary, I don't think I've heard from you. I don't know if you have thoughts. I welcome any input you have. I'm trying to make sure everyone's had a chance to speak at least at one point.
No, I don't think so, other than, have appreciated the conversation and the challenges, that exist around resources and how we do it in a way to make sure that we have the staff support internally to make that happen. Of course, my perspective as it relates to this largely is coming from the work that I do with the legal aid programs around access to justice. And so I guess lift up and appreciate the sense of urgency that a lot of folks have voiced around those issues and ways to identify innovative solutions that look at the issues broadly and systemically, I guess, because I think we all realize, and we've talked about previously, that the programs the legal aid providers aren't going to get to the point where they can fill the need that exists. So this is a different approach to this problem than what I'm usually working on when I work with our grantees. So,
Mark, why don't you try straw vote to see not in favor or not of the program proposed, but a straw vote on whether we want to make a decision today or not. Let's see where that goes.
Before we do that, can I ask a quick question? And it sort of goes to that point. I mean, both of these paths require legislative action, right? So it's been a while since I did all this stuff through the Bar Association, but can someone remind me what the timeline is for when we would have to have something submitted to the General Assembly in order to have it considered during session? Because I probably repressed that as a better way than saying forgotten. But I mean, that might help us as far as whether we want to jump into a vote now or wait a month, right? I mean, is timing of the essence? And so does anyone remember what that trajectory looks like in terms of going to the General Assembly?
This session is just about over.
Right.
It's the budget, and that's always the bellwether for the session's about over. The next session will be what's typically called the short session and has a limited list of things that can be considered. But they can always override that and do something different. So we are looking at probably a year to a year and a half before this could get into the legislature.
And, one thing I'd say about, whether we move forward with a vote today or have another conversation, I mean, if the next conversation is just to try to convince, me and Ashley and, you know, the other paralegal members on here, that there's a new option. The option, there is only one option. The option is you can have a limited licensing program if it's in the sandbox, or not at all. Then I don't need another meeting for people to tell me why they think that's important. So, you know, I'm trying to count the votes. Quite frankly, on the call right now, I can't remember if officers vote, and I can't remember if staff members vote. That will determine that, you know, the outcome of the vote, if we're voting whether to go forward on two paths, which is a limited licensing proposal and a sandbox, which I think is the issue that we're talking about today, not whether we, you know, have another round of this same conversation. I'm not particularly interested in another round of this same conversation, but that's what I'm doing. I'm doing the math. I'm counting the votes. So that's what I think the issue is to vote on. Two paths or one path.
Gotcha. I think that makes sense. Staff does not vote, Camille, and I think it's just committee members. I don't think I think like if we have some officers that are on, I believe Barbara, for example, is on the committee and an officer, so she would vote, but I don't think officers that would not be on the committee would vote. So
and what did you
Brian's
say about
got the official
staff?
list. Brian's got
What
the
did you
official.
say about
Staff does not vote. Staff has
does
no.
not.
Staff has no.
Correct. Yeah, we do not vote.
Okay.
So why don't we, I mean, I think taking a vote probably makes sense at this point. I mean, if we had another meeting, we could perhaps give people that hadn't had time to, you know, to evaluate it. We could have that discussion, but I think we probably had a pretty full discussion here. Alicia, I see your hand up. Yes.
I have a question.
Is it Alicia or Alicia? Forgive me. I've been to many meetings. I learned it and I've forgotten it.
It's Alicia. That's okay.
Alicia, thank you.
I have a question. So if the establishment of the committee is, you know, the logistics and the resources and all of that with the state bar, would it be possible to have one committee hammer out whatever you want that to look like, the details for the regulatory sandbox, and separately for the limited licensing? If the state bar isn't planning on housing the regulatory sandbox anyway, and you want that to be somewhere else, why couldn't one committee discuss both and hammer out both, but then the state bar still consider holding on to the limited licensing program and letting someone else house the regulatory sandbox, and then the state bar can approve those things as they will?
So I think the challenge, and Brian can add on if he wants from a staffing standpoint, but the challenge is they really are, I mean, they're kind of different tasks, and they're both pretty big tasks. So one is, you know, both involve adopting legislation, but also adopting that regulatory structure. So I don't know that we save resources, even if it's just one committee. They're kind of doing two different things. One is structuring how the sandbox process works, and the other would be what the components are of a limited license paraprofessional. So I'm not sure a single committee really solves the resource issue, at least from my perspective. Brian, I welcome your comment.
Yeah, I would agree. I think they are. If this subcommittee, well, of course, if this subcommittee recommends and the State Bar Council agrees that two separate paths should be pursued, then we would have. I would recommend two separate committees, because they're supposed to be separated. They're separate ideas. One involves just the licensing structure, of course, being a very lengthy and permanent thing. I think we saw in California, their projected timeline was 3 years, although it looks like they're already hitting some roadblocks. Just during this meeting, I see we have an email update from the Legal Innovation Survey that says that it looks like they're hitting the brakes on their regulatory sandbox. I'm not sure what that means for their proposal for paraprofessional licensure as well. But yeah, I think I would say they'd be separate. The whole notion of the sandbox being housed outside of the state bar, I guess that I wouldn't say that it's really housed outside the state bar, which is we would be partnering with a different, or one option, I should say, would be to partner with a different entity or group organization, namely something like Duke Law or another, law school or what have you. that would be able to kind of do a lot of the administrative aspects of running the sandbox, but it would still be under the state bar's umbrella. So yeah, I would still keep them separate to that end. And
Did
Mark, I
everyone
do
see
have some
Alice's comment. Sorry, that she said if there's another meeting, I can provide a more thorough analysis of the anticipated costs and resources with either or both proposals. Just, I wanted to make sure everyone saw that.
And Mark, I was just going to say, I do have some polls created
perfect.
to the extent that
right.
that you want to get anybody's. I created one that was on whether or not we should hold off and come to another meeting or have another meeting on this and kind of let everything simmer for a bit, or whether or not, or the other poll just being, do we proceed with one merged path or two separate paths?
Great. Well, I think let's do those polls, and why don't we do it in that order? That'll be helpful.
Okay. All right. I see we have a couple of votes in. You should see.
Yeah, it
the
looks like we have
prompt on
6. I see the tally. We have 6 in so far.
I don't
I
see
think
the
we have a
poll.
few more voting people.
I'm not.
I'm not seeing the poll.
I don't see a poll.
Oh,
I
okay.
don't see it either. Yeah.
All right.
Okay. Thank you for telling me.
Well, that's one way to control the results, Brian.
Yeah, it should have popped up. I'm going to end this poll
End the
those
poll
that
and let's
voted-
start again, just making sure. Let's have everybody, yes, if you don't see the poll, indicate.
Okay.
If you're
What
on the
you should-
committee and you don't see the poll, let us know.
Yeah, you should see a pop-up box that comes up, and I'm going to launch it right now.
I saw it from the chair. I don't vote, by the way. I just report on the vote, I guess, in the event of a tie.
If you do not see the poll, please let me know.
I still don't.
I don't see it either. And I've seen them before, but
Yeah, I don't know what to do about this. It's one of those things that if you look down at your the icons at the bottom,
yeah.
you'll Zoom icon. Does it look like there are 2 things there? You might want to click on that, and it might show that there's actually another window open that's called Untitled Advanced Poll.
So, yeah, and Brian, I'm showing that 14 people are receiving the poll, right? Which is
Right.
would make sense because there are 16 of us on the call, but you and Alice do not vote.
Yes.
Hmm.
So I'm not sure what to do. I see somebody else just found it. We got 7 now. Now, if anybody could not see it before and wants to share how they found the poll, especially if you're on multiple screens, it might be on a different screen as well.
I'm wondering if we should do this by raise of hands, Brian.
It might be
Right.
easier to
Given
do it
the
that way, just
difficulty.
to ensure.
I'm going to do that because I want to make sure everyone can participate. So, and actually, Alicia, you've got your raise hand up right now. Well, the other option is to do the voting. Let's do the raise hand, the same one that you would do to raise a question. Everybody know how to raise, or you can physically raise it and I'll count it. There are only 16 people or 14 voters. So if you'd like to vote today, please raise your hand. Okay.
Like to vote what?
Today, should we go ahead, proceed to vote today on this question? The other option, and if you want to wait and vote at another time, you keep your hand down. So I see 1, 2, 3, 4, 5, 6, 7. I see 7 in favor. If you're opposed, if you want to wait and vote at a future meeting, could you put your hand up? I see 1, 2, 3, 4. Opposed. Barbara, I think your hand's still up, but is that from you voted both
Sorry,
ways?
I didn't know
You
if you
might be
counted it.
I think I have a 7-4, which would be in favor of voting today. So that motion carries, and we're going to go ahead and vote. Brian, how had you, I want to do the hands again because the poll doesn't seem to be working. How would you worded it though? You're good at teeing it up.
So I think the question to be decided is, should the subcommittee recommend pursuing one path, e.g. the two ideas merge, sandbox and limited license? Or should the subcommittee recommend two separate paths, sandbox and separately a limited license? So kind of one path versus two paths.
Because to me, I guess I think about it a little differently. To me, it's more a matter of which to do first. I mean, we've already said that we should pursue limited licensure. So I'm a little concerned that that wording suggests we're saying not to do limited licensure, where I think our strong consensus was limited license paraprofessional is an idea worth pursuing.
Right. That
So
was
I
not
guess-
my intention in informing.
No,
that,
I know, but I think what I would propose is my recommendation would be that we first pursue a regulatory sandbox with the expectation that as part of that, we would evaluate limited licensure and that we make that the priority at this point. That's really what I'm suggesting. So I think that's what that's what I'm asking for a vote for. So you can vote for or against the idea of first pursuing the regulatory sandbox with paraprofessional licensure as part of that.
Okay, Joshua, I've got a question.
Yes, Joshua.
So in your first sentence, you said something about making something a priority, which when we had all these votes some months ago, we decided not to put any. Did you mean to say sandbox with paraprofessionals as being the priority in the sandbox, or did you mean?
Yeah, that's good question. No, what I meant is that the first priority of the state bar should be to pursue a regulatory sandbox initiative, comma, which would include consideration of paraprofessional licensure. That's what I'm envisioning. So the recommendation is let's look at the sandbox with the expectation we'll get proposals from paraprofessional licensures that we can then evaluate through the sandbox to build some experience that in my mind would then lead to a state bar paraprofessional program, which again, I think this committee has said is a good idea. So it's really it's a timing question. Any questions about how I've worded the proposal? Jeff?
So what does a no on that mean?
Yeah, a no means that you don't think we should prioritize the sandbox. In other words, I think, as SM Kernudel said earlier, we should do dual track or both programs. I think Alicia may have voiced the same thing. So I think if you're voting no, you're saying we should not do the sandbox first. We should, we should do both. And Alice is a good clarification. I do mean paraprofessional practice, not licensure. I think I may have used the term licensure. Sandbox is going to be broader. So it's going to be proposals for paraprofessionals to do certain activities. Again, we don't have to prescribe what it is because the whole sandbox approach is they can decide, but it wouldn't be a licensure program. It would be a paraprofessional provision of legal services through the sandbox is a good clarification.
And, sorry to press the point again, but is the state bar leadership voting on this? Are they if they're on the committee or not on the committee? And do we know that? I think you mentioned Barbara's on the committee.
Barbara's on the committee. Darren is not on the committee, right, Darren? I see you nodding. And it did not vote. So Darren is not voting. Todd is on the committee, but Todd is not with us. He may be rejoining at 3:30, so that may, but if he is also a committee member, Camille, so I think Todd and Barbara are the state bar members or committee members. Darren's not, our president's not.
I think officers are always ex officio members of any committee.
Yeah. I was going to say officers are generally considered ex officio members of the committees.
Okay.
Well, don't devalue me.
All right.
Okay, I'm sorry, I have a question now. So if
Go ahead,
we're voting no, then we're saying, then we want to move forward with limited licensing.
Yeah, I think if you're voting, the vote is to prioritize the sandbox. So I think if you're voting no, you're saying we don't want to prioritize the sandbox. You're suggesting we continue. Our current recommendation is that the state bar do both. So this is a recommendation from the committee to prioritize the sandbox.
And then if that motion did not pass, to her point, then there could be another motion if they were saying we don't want to, we want to prioritize paraprofessional, or we want to do them both at the same time, whatever.
Correct. Okay. Thank you, Barbara. That's a good clarification. All right. Any other questions about the vote? All right, then if you're in favor, can you raise your hand? In favor of the proposal to consider first the sandbox? All right, 1, 2, 3, 4, 5. Just double, help me count too, Brian. I think I see 5 hands, right? That's what I see. All right. And then if you are opposed or voting no, go ahead and raise your hands to vote no. So I see 1, 2, 3, 4, 5.
I see 6.
You see 6. Hold on, my screen just shifted. Okay, 6 no's. In which case that vote fails.
Can I ask a question?
Yes, go ahead.
Jeff, why did you vote no?
I still want to see, I mean, that's part of why I'm asking, what does no actually mean? As I understand it, I don't want to prohibit a limited licensing process from moving forward or being considered. I mean, that's what I'm trying to wrap my head around is what, do I want the sandbox to be considered expeditiously? And do I think it can address a lot of points? Absolutely. I'm probably the most obnoxious sandbox bull in this room, but at the same time, I don't want to preclude something that would allow for an independent licensure or something that, again, I haven't wrapped my head around how to address the issue. And I'm not saying I can do it better than forming a separate implementation committee on a paraprofessional licensing on how do we make it so people can opt into a credential that is going to, not run the risk of collapsing. I mean, it's just something that I'm not saying that implementation committee is not going to have its own problems in terms of its scope. I don't want to preclude it either.
I clearly wasn't voting to preclude it. I was voting to say that a sandbox was the more realistic way to get it.
Well, realistic and expeditious is sort of why I did it. I'm like, what can we put in place the quickest that gets us moving in the right direction of greater access to justice? Rightly or wrongly, that's where my head was.
Me too.
Yeah, and I'm not confused by what my options were. I am very interested in sandbox moving forward. I'm very interested in limited licensing path moving forward. At the same time, on parallel track. I'm still confused about the voting. I thought I just heard that state bar leadership were ex officio and didn't vote. But that's not what happened. So I'm confused by that.
Ex officio meaning that the state bar officers are kind of considered voting members of state bar committees. So they do vote.
So they do vote.
Yes, they do vote.
Okay, thank you. Thanks for clarifying.
Sure.
Can you hear me, Mark?
Yes, I can hear you, Josh.
So it's like I'm almost Mr. Practical.
And here
Oh.
comes Todd.
So the only thing I'll say, guys, I mean, this is Joshua keeping it real. We're going to send a recommendation, to the bar, who's going to see a split vote down the middle, instead of sending a recommendation that shows this group of people got together and at least came to a consensus. I'm not saying that's right or wrong, but all I know is on the committees that I've served on for about 2 decades, when split votes come along, sometimes that tells folks that, the folks that we asked to look at something for a year or two couldn't come to a consensus. Why do we even need to take it up? The vote's already happened, so I guess it's a done deal, but it's been voted on, I think.
So Todd, I know you had to go to another meeting. We were doing what I think Mac would call a straw poll, but try to get a consensus of voting today. And I think the consensus was we should vote today, and then a vote on whether we wanted to first consider the regulatory sandbox ahead of a paraprofessional. And that vote failed by a vote of 5 in favor and 7 against, right?
5 to 6.
5 to 6, 5 in favor, 6 against. So we do not have a recommendation to move forward there. Jeff Kelly, I see your hand.
Yeah, and maybe this is me not understanding the vote because logistically, I'm just trying to understand in terms of what the yes and no actually meant. I mean, not to split hairs on it. It's just I feel like I voiced why I voted no, and I'm hearing differing interpretations about whether that was actually the intent of it. So that's just what I'm trying to find out is if we vote yes on this, what would be presented to the State Bar Council, presumably at the next meeting, and what is, again, I don't want to do anything that is precluding or otherwise getting in the way of paraprofessional certification being pursued as its own standalone, especially.
Thanks, Jeff. I'll address that in a second, but I see Lakeisha's got her hand up too. Let me get her comment.
I'm thinking that this is not the vote that's going to be presented to the bar. I'm thinking all this vote was to say we're not deviating from what we unanimously agreed upon before this meeting.
Yeah. Again, to be clear, I think what we have previously done is recommend for further evaluation the paraprofessional licensure program, and we have recommended for further action the regulatory sandbox. And we also have several other things that we said down the road, we think these are also good ideas. But we have done as a committee, we have proposed those two. What I brought, which I don't think we're certainly not unanimous on or have, which are split on, is the idea of suggesting to the state bar, hey, you should prioritize the sandbox. I mean, I think the state bar and the officers and executive committee are going to do the priority that they want to do. I see Alice, who can't speak out loud, has just said something. Let me defer. Let me see what her comment is for everyone. Give a chance to read it. Hold on one second. Alice is suggesting, and she may be right, that given how split we are, maybe another meeting to talk more, to dive into some of the resource and staffing questions. That may make sense to talk further. And I think that may be well taken. I think if that, without that current vote, we're where we were at the beginning of the meeting, which is we're recommending both limited licensure and regulatory sandbox. That's what our committee has recommended for further study. I'd be happy to entertain any other motion. Thank you, Ashley. I see your comment too about,
Mark,
Yep.
I've got a question.
Yeah, go ahead, Todd.
I apologize for having to get off and jump back on, but there was a 5-6 vote on what precisely?
The 5-6 vote was my perhaps inartfully worded proposal, which was to prioritize and recommend that this committee recommend the state bar first adopt a regulatory sandbox, which would include paraprofessional practice as part of that, and make that do that first before creating a committee on paraprofessional licensure. That was my recommendation as chair, and that vote failed 5-6.
Okay, I don't know if this is procedurally proper, but since I've been on this committee since the beginning, before I became an officer, if it is procedurally proper to register my vote now, I would certainly be in favor of your initial recommendation that we go with the sandbox first, which I assume would tie the vote.
Yeah, I think it would, and I'm trying to now think of the Roberts rule, the procedural piece on that.
Yeah.
Since you had to step out, I don't know the answer to that.
I think there have to be a call for a revote or something. I don't have my Roberts rules right in front of me, unfortunately, but I do think even if, Todd, you were present and cast your vote in that form or in that manner, it would be 6-6, and therefore the proposal would have failed anyway. So,
although, would I then vote to break the tie, Brian? Because I'm not.
Oh yeah, I guess as chair, you would have voted to break the tie. So there you go.
No one could guess how I would vote, but yeah.
Right.
Exactly.
Well,
Jeff,
doesn't
did you
the
have
chair,
your-
doesn't the chair, doesn't the
Figured out a
chair
way
break ties?
to move forward in that direction.
Jeff, you had a comment?
Yeah, I mean, sorry because I'm always on the edge here of this, but I'm trying to, again, what practically does a vote in terms of prioritizing it do to a track for paraprofessionals, because I think that, I mean, I can conceive of where most of what we're talking about here in terms of creating the programs, allowing for people to practice in the way that paraprofessional model, I agree with all of that. But what does it do in terms of the timetables for both of those tracks? And that's just what I'm trying to piece together here. And that's really my primary reservation, because I'm prepared to move forward with the sandbox.
I think part of the challenge is this committee can only do so much. I mean, I think I've been trying to push the kind of edge of our mandate. Our real mandate is to simply study and recommend items for further evaluation. I think really we've done that, and we have voted in favor of both of these ideas as worth further study. I think my thought was, given the limited resources and the concern about how to get all this done, was to try to provide a suggestion to the executive committee and the officers about a way to prioritize it. I think the reality is that the executive committee and the officers can decide how to move forward on one or both fronts, regardless of how this committee votes, because our committee is simply recommending a move forward. So what we're doing here, it really isn't binding on anybody, but I think it's important enough. And obviously we've all invested a lot of time and effort into studying this and thinking about it, that I wanted to have a discussion about some of my thoughts on a potential way to move forward, and get your thoughts on that as well, because I know we've all worked hard. We all care a lot about these proposals and the ability to make an impact. So while we don't have the ability to compel anything, compel creation of a committee or a program, I think I thought it'd be useful to give suggestion and guidance. And I think we're obviously somewhat divided on the best approach moving forward. Todd?
Oh, I just haven't taken my hand down, sorry.
That was before? Oh, it's okay.
Apologies.
So I think we have, Alice has a good point that maybe another discussion and a relook at resources, given we're divided, probably makes, that makes sense. I could enter, if someone else wants to make a motion, that would be in order as well. If someone else wanted to propose something, I'm open to other motions, since the motion I proposed failed. Excuse me. Go ahead, Camille.
One thing I'll say is, coming into today's meeting, I think if there had been more transparency on the front end, and if there had been a continuation of conversations from our last meeting in August, I think I certainly would have felt better. I have seen you guys twist yourself in knots today to talk, in some language that makes us all feel good. And I really appreciate that. I do, because I try to be really careful and tactful with my language until a minute ago, when I got a little perturbed. But I understand all of that. But I think what happened is, we had our last meeting in August. There was no indication that that was our last meeting. The indication was that we were still sort of on track to create a report. We formed some working committees. I was assigned to a working committee, and all of that went away. And what I'm guessing, and I have no idea, but what I'm guessing is happened is that there has been a hue and cry among state bar leadership. And it must be among leadership, because it certainly hadn't been among the bar at large, with the exception of if folks started getting word, that you need to start voicing your concerns about this. And that's okay. But what I would have loved to have seen is for the committee to have had a September meeting, where the leaders of our committee and our state bar staff would have said, guys, we have run into some roadblocks, and here's what's going on. And then we would have met again in October, and we would have brainstormed, how are we getting around these roadblocks? So that's what I'm going to say. We can probably vote 10 times. And if we get the right number of people on the call, we'll get the vote where we need it to be. And if what you're telling me is this is never going to move forward unless we stop voting for legal limited licensure to move forward on a separate path, I would have felt so much better about that if we could have had transparent conversations about that for the past few months. That would have made me, I would have, there are always things I'm willing to compromise and give up on for the greater good. And make no mistake, I believe the greater good here is access to justice. So I would have been so much happier with that. I think today is an example of what happens when you get rid of transparency, you go in the dark and you start having conversations. So, from my perspective, I don't want to do this for another hour or another 2 hours in January. I know where you guys stand. I know where I stand. Alice explaining the budget to me. I mean, I don't need that. I'm happy for the committee to do the work that we need to do. But this to me is where the committee has broken down and fallen apart. And when there is no transparency, what happens is a whole bunch of behind the scenes conversations and maneuverings that make us less trustful of one another, no matter how masterfully it's presented. And I just have to say, like, Mark and Brian, I have the utmost respect for y'all. And I think you presented everything today masterfully. It's great. And if there is truly no way to move forward but this way, and it is partially due to resources, but it is largely due to the inner workings of the state bar, I wish we could have said that. My voice, my votes might have been different. My compromises might have been different. So I will say you started this by saying some straw votes. Look, I know that, Todd was off the call for a few minutes, and maybe I took that as a win for a moment. And, Todd wants to get his vote casted. I respect and hear that. So I'm sort of rolling over dead at this point. I'm not defeated. I'm not sad. I'm not mad. I'm not angry. I promise. I am so happy to be a part of this conversation. I am so happy to be a part of this dialogue. I believe in the passion of everyone on this call. I truly do. So I don't want to be viewed as the troublemaker today. I guess I'm trying to say transparency and trust are really important. Today, I felt coming into this, when I heard the direction that we were moving in, I felt that a little of those were lost. And so I'm just going to lay that on the table. I was disappointed by that. But I want to do what's best for the citizens of North Carolina.
If I can just kind of quickly say, Camille, I respect you. I do disagree that there's a lack of transparency. And if anything, blame this on me. When we finished the August meeting, we were looking towards October, and getting past the October meeting, of course, is a big task for staff. There wasn't a plan to schedule another meeting in September. But once we got past the October meeting, then suddenly, as I was prepping the report, and I have a draft report that I've been working on, in addition to the myriad other things that we do here at the bar. But as I was putting this together, and as we were talking about the next steps, that's when it was really hitting me just how significant of a task all of these different recommendations were that I was trying to summarize into a report, and how it did not seem realistic that we could pursue everything. Not to mention, yes, there's some, I do call it skepticism. I'm not trying to twist myself in knots, because I think there are genuine interests in solving a problem here, but there is also genuine skepticism of, well, how is this idea going to really change things? Whether you're talking about Sandbox or whether you're talking about limited licenses, fee sharing with non-lawyers, all of these things are just all ideas. And so that's where I think Todd made this point earlier in the conversation that when you have evidence, you can point to something that makes me feel more comfortable. And as the staff person that's looking at this stuff and putting it all together, trying to put it together and then ultimately having a conversation, the fact that we're having this conversation to me is that step in transparency, because frankly, I think a number of us, and I will just kind of say I certainly am in this camp, started thinking about this differently of what can we realistically accomplish. All the different concerns that I've heard about Sandbox, I have the same concerns for the limited license, that we could push ahead on the limited license and find ourselves with nothing at the end. And that's the sort of thing that I felt changed how I was looking at things. So to that end, I want to, I feel like we have been transparent. I think the bar and the subcommittee has been making a point of doing that by putting all these meetings on YouTube. We're streaming this right now. The conversations that occurred to kind of bring this to the subcommittee today, I think were the product of trying to feel out, particularly as maybe I was thinking about things differently. Is that an idea that's worth bringing to the subcommittee? And that's where we are today. So I'm sorry that you don't feel like it was transparent. I was hoping that our conversation would be just that, another positive step to find a collective and collaborative solution. But nevertheless, if to the extent that you wish you would have had a meeting before December, please blame me. That's on me.
Alice, did you have your hand up? Did you want to say something or type something?
I think I saw Alicia had her hand up.
Oh, was it Alicia? I'm sorry. Alicia, did you have anything you wanted to add?
Well, I guess, I've had conversations with Brian since the last meeting. So, I don't feel that he was trying to not be transparent, but I think that is kind of the outcome. This came out of left field. And so there really hasn't been a whole lot of time to consider the pros and cons. I guess, I guess when I think about the regulatory sandbox, I understand how it works. I've been sitting on another committee that's been discussing this for a year. It's like asking you to buy a house unseen. Like, you just don't know what the details are. And so it's hard for me to, get invested in something where I think the paraprofessional licensing or whatever you want to call it would be lost. I feel like there's this, and I could be wrong, but I feel like there's this, let's do the regulatory sandbox. Yes, we've got, FinTech and InsurTech, that was presented in April and passed in October at lightning speed, and everyone seems to be, riding on the momentum of that. And I believe that will facilitate access to justice, just like the paralegal program will. But I guess my concern, it's just odd to me. Like, I feel like there has been a lack of communication. I feel like there's been some side conversations. And I'm not saying that those can't happen. It just doesn't feel very transparent. And so I guess I'm feeling, a little distrustful about the process. When I think about the regulatory sandbox, I think, businesses going in with law firms and attorneys and working on innovations and all of that is great. And so I can understand why the lawyers would be, yeah, let's do that, because that benefits us when they're really still looking at paraprofessionals as competition. And so I just have some concerns. I already voiced this earlier about the authenticity. And if we don't have any of those details, like, how does this really move forward? We said, well, let's prioritize regulatory sandbox and consider, where the paraprofessionals fit into that is just a little bit too uncertain for me.
Thanks. Jeff Kelly.
Yeah. So, I guess for me, the question and issue I've been grappling with is, if all we're doing, and thank you for some of the earlier clarifications on the process. I'm a bit of a state council newbie when it comes to what actually is recommended, what's voted on by them versus us. To me, it probably doesn't come as a shock. My highest priority is getting implementation committees formed and certainly on the sandbox, and I don't want to preclude the paraprofessional, because we're talking in abstracts here. I think that's why we've had such high levels of support for every single idea. And so that to me is kind of the practical challenge, that I don't want to preclude something being considered separately. And these are processes that are going to take a lot of time. I think on both fronts, we're going to be looking at marshaling different resources. And so the more that we can do to get those conversations started, or frankly, I mean, for my sanity, knowing whether or not it's something the State Bar Council would go for on either set of ideas, that to me is sort of the litmus test for if, for example, we present to the State Bar Council, these are the two proposals, this is how they could interact, but it's up to you to vote on which ones move forward or which ones you're going to form an implementation committee. If they shoot down one but allow the other, our decision here is, I think everyone would be probably pretty close to unanimous on how to react to that. So that's maybe why I might appear to be voting inconsistently, but that's also where I think that if this is a practical question, if this is something that we're talking about post State Bar Council presentation, how things could operate, yeah, if the only option is the sandbox, then I will advocate, day in, day out in terms of how that could accomplish the same missions. But if we're talking amongst ourselves here, that's something that I want to make sure I'm fleshing out and understanding.
Great. Thanks, Jeff. I know we're getting close to 4 o'clock and some people have had to drop off already, but I do want to make sure. Anybody else have a short final comment they want to share? I appreciate the candid dialogue in this meeting, just like the other meetings. I think these are challenging issues. And, again, my takeaway is this committee wants both. We want a limited license in a paraprofessional program, and we want a sandbox. That's my takeaway. That's consistent with how we voted earlier. And that's how I interpret this meeting. And I think, I'll commit to try to work with the State Bar to see how to make that happen. Again, I have concerns on some of the logistics and implementation, but I hear that's the message that I'm getting from this committee. So I think we'll go forward. We'll be in touch in terms of another meeting or what we take up or how we want to handle getting more information on resources. So I appreciate your continued dedication of time and your candid discussion. It's okay to me that we disagree and have different perspectives. I mean, that's part of this dialogue. They're challenges. There's not always one right answer. There's challenges moving forward. We come at it from our own perspectives and history. We've got a diverse group on this committee. So we all want to do something to improve access to justice. We're trying to figure out how to get there. And it's okay that we're not always on the same page. So I appreciate everyone. And we need to be able to have candid, open, civil discussion and voice frustration when we feel it. So I think we need to do that. And I appreciate all of you for doing that today. And thanks for your service on the committee. And I appreciate it. So even if we meet again, it won't be before the holidays. So let me also wish all of you a happy holiday, happy new year. Hope it's a good time and everyone can have some time to rest and reflect. And thanks for all the work you've done on this committee and for the State Bar. I really appreciate it. So thank you guys.
Thank you, Mark.
Appreciate it.
Everybody have a good one.
All right.
Thanks.